While we are watching this ongoing hearing, I want to bring in senior fellow at the Cato Institute, Ilya Shapiro. He's on the phone with us now. Ilya, thank you for joining us. Ilya, before the hearing, a lawyer for President Bush released over 40,000 pages of documents on Kavanaugh. President Trump has also claimed executive privilege, blocking more pages from being released. Democrats are arguing they still don't have enough of the documents they would like to see pertaining to Kavanaugh's record. Is all of this typical for Supreme Court confirmation proceedings?
No, nothing is typical anymore. I don't think anything's been typical for a number of years in American political life. What's going on here, there's a couple of things. So first of all, most of the senators who are making the biggest deal about these documents have already said they're going to vote no on Kavanaugh. So it's clearly a political game. Some of them will be running for president in 2020. So it's that sort of thing. And then for the others, it's not clear what they've reviewed, what they actually want to see, because most of the documents that were produced, they were first what's called deduped, meaning multiple copies of emails and attachments and technical things like that. When you're doing a big document production, those were taken out, and then the ones who were designated as confidential, Chairman Grassley, the Judiciary Committee chairman, made available 24/7 to members and staff the things that were called committee confidential. That is, that are not posted on the website. Anybody, in fact, can see the things that are public. And apparently, at least as of this morning, nobody had, none of the senators, Democratic senators or their staffs had reviewed these. So I think a lot of this, as the whole debate over Kavanaugh isn't really about the nomination, but about the larger political scene, the President Trump's legal problems, the leftover hostility after the election, things like that. And so now we're seeing this play out in this particular way. This is definitely unusual, a kind of a rolling filibuster to start the hearing before the opening statement started. And we'll see how it proceeds, what kind of questions they ask.
Absolutely. And just going back to the documents again, the Judiciary Committee has said they had reviewed more material for Judge Kavanaugh than any other Supreme Court nominee in the past. So is this an argument over what material exactly they would like to look at, or is this more of a debate over the fact that thousands and thousands of pages were dumped at the last minute and no one had time to go through them?
Well, part of it, the latter, there was a small number, a relatively small number in this sort of thing that was produced last night, 7,000 documents apparently, which the majority staff apparently went through. A lot of these papers are just routine sort of things that don't really reflect on, on Kavanaugh's political, little and legal thoughts. Most of this is just throwing numbers back and forth, trying to score political points, because at the end of the day, most of Kavanaugh's substantive work, his legal opinions, his speeches, his writings, that's already been public. Now, already that is much more than anyone who has previously been nominated, before we get into the reams and reams of material from his service in the White House that have less to do with his judicial philosophy.
Right. Now, of course, as we know, there are a couple of hot-button issues here, especially for Democrats. Roe v. Wade is one of them. In the past, Kavanaugh did call Roe v. Wade settled law, but last year he came out against a controversial ruling that allowed a detained, undocumented teen to get an abortion. What effect could Kavanaugh have on abortion rights if confirmed? Because there are plenty of people in the legal community who might support, these rights for women, but who will also tell you that Roe v. Wade is not a perfect case.
Right. And this is more of a typical question for confirmation hearings, setting aside kind of the political theater. Because we have to understand that John Roberts, the Chief Justice, becomes the swing vote. It's not that Kavanaugh is replacing Kennedy, and therefore all of a sudden he's the deciding voter and everything. Roberts is more moderate than Kavanaugh, and he is very much into holding the line on precedent and stare decisis, those sorts of things. So he'll be very cautious. I can see with Kavanaugh that certain types of restrictions that might have been struck down with Kennedy would now be upheld, but I think it would take 2 or 3 more justice replacements to really put Roe v. Wade in any danger.
All right. So another hot button issue, though, of course, is whether or not a sitting president can be indicted, whether or not a sitting president is in any sort of legal jeopardy. Where would Kavanaugh fall on this?
It's hard to say, because it's never happened. Certainly, President Nixon, when he was under investigation, and ultimately resigned, President Reagan, President Clinton were all under investigation. but they kept nominating people, and the Senate took them up. Kavanaugh has said many things. It's obvious that his thinking on executive power has evolved over the years, and it really depends on how the question comes up, because whether a president can be subject to subpoena is a different question than whether a president can be indicted, and if that indictment comes, well, that indictment, does that have to be frozen until he's out of office? These are all novel things, and certainly Kavanaugh is not going to reply to a hypothetical one asked. There's lots of things that point in different directions, and you can't judge that on anyone that's currently on the court on what they would actually think about that.
So there's nothing in his legal history to date that would indicate his feelings on executive privilege?
Well, he has written that potentially President Clinton being investigated and having to do depositions to be part of a civil suit maybe distracted him from going after Osama bin Laden. So maybe there's a part of him that feels that certain type of process has to be paused so a president can go about doing his job. But what the nature of that is, how it all plays out when an actual lawsuit is presented to the Supreme Court, it's kind of speculation on speculation. But he has in his record, he's come out both as a strong defender of executive power and as an investigator of presidents in the executive branch. So it just really depends on how the legal issues shape up.
All right, Ilya Shapiro, thank you so much for that.